effect on modern American politics. In response, Congress passed the Ethics in Government Act in 1978 as a means of providing accountability in government. One provision of the act authorized the Attorney General to request the appointment of an independent counsel by a court called the Special Division. The purpose of the independent counsel is to investigate high level civil servants and prosecute them for violations of federal criminal law. Congress granted the Attorney General sole removal power of independent counsels for cause. Independent counsel Alexia Morrison investigated the role that various officials in the Department of Justice played in potentially obstructing a congressional investigation. Specifically, Morrison alleged that certain Environmental Protection Agency documents had been improperly withheld and that Solicitor General Ted Olson had given false or misleading testimony to the congressional subcommittee during the investigation. Morrison asked a federal court to issue subpoenas requiring production of the documents. Olson fought the subpoenas and challenged the constitutionality of the act as a whole. Olson argued that Morrison had no authority to act, much less seek subpoenas, because the portion of the act authorizing independent counsels violated the Appointments Clause of Article 2 of the Constitution by allowing appointment of a principal officer by someone other than the president. Olson further contended that the act violated separation of powers principles by reducing the president's power to remove executive officers. The trial court found in Morrison's favor, denied the motion to quash, and found the defendants in contempt for failing to comply with the subpoenas. Olson appealed. A divided court of appeals reversed, finding that an independent counsel is a principal officer, not an inferior officer. And as such, the Court of Appeals held that the act is invalid because it does not comply with the Appointments Clause. Morrison appealed to the United States Supreme Court.
Now, before we continue, I want to point out, you can search it on TorySays.com or Big League. I pointed out that Mueller was an inferior officer. I point that out to you.
Chief Justice Rehnquist, writing for the majority, found that the act was constitutional. First, Rehnquist made clear that the requirement that officers be chosen by the president and approved by the Senate under the Appointments Clause applied only to principal officers. Congress was free to allow the president, a department head, or the judiciary to appoint inferior officers. Rehnquist concluded that an independent counsel created by the act was an inferior officer because the independent counsel could be removed by a higher executive branch official and was vested with only limited authority, jurisdiction, and tenure. Next, Rehnquist noted that interbranch appointments of inferior officers is authorized by the accepting clause, and Rehnquist concluded that vesting the appointment power in the judiciary was both logical, given the difficulty involved in having the executive branch investigate its own officers' misconduct, as well as permissible, because the job was consistent with the traditional functions of courts. The majority concluded that the creation of the special division does not conflict with Article 3 of the Constitution, which limits the judicial power to cases or controversies, so long as the division did not do anything outside the specific functions authorized by the Act. Finally, the majority turned to the question of whether the Act violated separation of powers principles. Because Congress vested the power to appoint the special counsel in the judiciary and the power to remove the special counsel in the Attorney General, Congress wasn't usurping the power of the executive. Further, neither the requirement of good cause for removal nor the Act as a whole prevented the president from performing those functions constitutionally vested in the executive branch. In light of this, Rehnquist concluded that the Act did not violate separation of powers principles. Justice Scalia dissented, basing his opinion on an originalist interpretation of separation of powers. Scalia argued that the act unconstitutionally deprived the president of exclusive control over a purely executive function, that is, conducting criminal prosecutions. Scalia further took issue with the characterization of the independent counsel, who was subordinate to no other executive officer, as inferior, and concluded that the limitations on removal without cause violated the precedent set in the case Humphreys Executor versus United States. Morrison versus Olson was a hugely important and highly controversial ruling that had a significant impact on separation of powers issues, interbranch appointments, and the use of independent counsel. Congress allowed the act to expire in 1999 and created the U.S. Department of Justice Office of Special Counsel to replace it. Justice Scalia later referred to this case as the most wrenching case he decided, both because it came out wrong and because Chief Justice Rehnquist wrote the majority opinion. Rehnquist had been head of the Office of Legal Counsel, and in Scalia's mind, should have been more aware of the importance of the president's prosecutorial authority.
All right, so Scalia. Let's listen to what his dissent was, because you're gonna see where this is all going. You'll understand.
I am one of the 8 who filed dissent in this case. And I suppose when one dissents from as many of the court's decisions in one day as I have today, you get to discuss it. I discuss it because I think it's one of the most important opinions the court has issued in many years. To many people, it may seem that this case is of some political interest, but is not likely, now or in the future, to have any proximate effect upon their lives or the lives of their children. It does not, after all, involve freedom of speech, freedom of the press, freedom of religion, or any of the wonderful guarantees of our Bill of Rights. That is wrong.
If you took a survey of people and asked them, name Justice Scalia's most important, greatest opinions, Morrison versus Olson's dissent would appear on almost every list, which is interesting because it was a lone dissent.
I think he had a very, very astute grasp of the real world dynamics of power and how law would change relationships of power. And that's what is at the heart of the brilliance in this dissent.
At the time the decision came down, most people in the academic world, most law professors thought the majority was right, Justice Scalia was wrong. As time has gone by, it's almost a consensus that Justice Scalia was right.
Post Watergate, they had just gone through the Nixon presidency, and there was a widespread, even bipartisan sense that you couldn't trust the president to investigate himself or his highest ranking subordinates.
The conclusion that emerged out of Watergate was we need a system in which an experienced prosecutor has enough independence that the president can't just turn around and fire that person.
Congress introduced by statute in the Ethics in Government Act an alternative mechanism for policing what it saw as the prospect of executive malfeasance.
A panel of judges would appoint a special prosecutor, called in this case an independent counsel, to investigate the activities of the person in the executive branch whose conduct was being questioned. And that's what happened in this case. The controversy that led to the appointment of the independent counsel was this dispute between congressional committees and environmental enforcement agencies in the executive branch. It was the responsibility of the Office of Legal Counsel, the office that I headed, to provide the president with constitutional advice as to whether this was an appropriate occasion to exercise executive privilege. That angered Congress, and Congress decided to conduct an investigation over how the Justice Department handled that entire controversy.
Morrison was appointed as what is called a special counsel. The special counsel was a law enforcement official, technically part of the Department of Justice, but not actually answerable to the hierarchy of authority in the Department of Justice. He had, by statute, all of the authority of the Attorney General of the United States to pursue criminal investigations and prosecutions within her defined authority, without having to answer directly to the Attorney General or to the President.
Ultimately, the independent counsel subpoenaed documents that related to the work that I had done. So we resisted the subpoena, told the independent counsel that we would not produce the documents, and then told the court that we were not producing the documents because the independent counsel did not have the right under the Constitution to subpoena those documents. That set up a judicial challenge to the existence of the independent counsel.
The big argument is whether or not you could have a special counsel who operated independently of the president, because she could only be removed for very narrowly defined clauses. Justice Scalia's dissent today is famous for his very, very strong and powerful rhetoric about that aspect of the case.
The majority opinion, written by Chief Justice Rehnquist, looked at various different aspects of the independent counsel provisions and said, well, it's not too much power.
It was deliberately structured as a case-specific, fact-specific. You have to look at the particulars of each instance. So it doesn't have the character of what we might call a rule. And this is also one of the reasons why Justice Scalia got so upset about it.
A little bit of erosion here, a little bit of intrusion here. In the totality of circumstances, it's not too bad and it's tolerable. It's the kind of situation that Justice Scalia recoiled from.
But I do think the principle that Congress has the capacity to create some structure for ensuring an independent, impartial, legitimate investigation of the president or the president's top aides when there's a strong enough basis for believing they may have committed crimes, that the principle that there's room in the separation of power system for some structure that allows for that, I think is appropriate. And that's what is not permitted under Justice Scalia's very, I would say, simple, mechanical approach to this complex problem.
Justice Scalia's dissent in Morrison versus Olson was a very forceful, very powerful, rhetorically flourishing defense of the position that the president has to be able to fire at will, at least, at a minimum, anyone who's exercising law enforcement power within the executive.
I would say Justice Scalia disagreed with the majority for both a kind of formal set of doctrinal or constitutional reasons, and because he thought that beneath those reasons, there were real questions about the distortion of the balance of powers.
That the president must have the unified and exclusive power to execute the laws, so that we, the people, could hold the president responsible for the ways in which the laws were executed.
Justice Scalia would have us believe that the framers of the Constitution made a conscious and focused decision that even when the president or his or her top aides are being investigated, it's still the case that the president has to have full control over that investigation. I don't think the framers focused on this particular issue. They talked about politically removing the president from office, obviously, because the impeachment process is established in the Constitution. But they simply didn't give any thought one way or the other as to what the structure for an investigation might be of whether the president or his or her top aides had committed crimes, and what the structure for prosecuting that might be.
Didn't the framers consider the possibility that there might be a rogue president and rogue law enforcement machinery? Of course, not only did they consider it, they wrote 6 separate provisions into the Constitution to deal with that. Those are the provisions for impeachment and removal. The Congress believes that the president is misusing power. There is a procedure specified in excruciating detail in the Constitution